Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 25-7007. Titan Consortium 1 LLC versus Argentine Republic appellant. Ms. Roman Murphy for the appellant, Mr. McGill for the appellee.
Good morning.
Morning. May it please the court, Rethna Ramamurthy from Cleary Gottlieb for the Republic of Argentina. The limitations period that should be borrowed in this action is the 3-year statute of limitations from the federal or DC arbitration acts. The district court was incorrect to choose instead the 12-year period governing expiration of a DC judgment under the DC code. Under a 3-year limitations period, Titan's action is time barred and should be dismissed. So to take a step back, this is an action under Section 1650A, and it's undisputed that Section 1650A does not have its own limitations period, meaning that one needs to be borrowed. So that means finding a closely analogous cause of action to borrow from. And the nature of this action is one in which Titan is seeking entry of judgment on an arbitration award. And the nature of the action is really underscored by the basis for jurisdiction that Titan invokes, which is Section 1605A6 of the FSIA, which covers actions to confirm arbitral awards. Based on that, the closest analogy here is another statute that also provides for confirmation of arbitral awards.
Can I ask a predicate question? My understanding is that when the, I don't know what you call it, but the appeal or the case was taken to the annulment review process, that a provisional stay was entered. Was a stay ever entered for the balance of the time the matter was pending before the annulment committee or whatever it's called?
No, Your Honor, I believe it was not, and there was no stay that would have prevented Titan from filing its action in a timely manner here.
That's not what I'm asking. Is just whether a stay had been entered during, I thought it was, you know more about this than me. I had thought it was at least not uncommon for their stays to be entered during the annulment proceedings. Is that wrong? But one just wasn't entered here. There was just a provisional stay and then it expired when? After 30 days or?
I can check on that and I'm happy to, when I come back on rebuttal, I can address that for the court. So going back to the idea that we want a close analog here and a closely analogous action would be one that is also about confirmation of an arbitral award. Under federal law, that takes us to the Federal Arbitration Act, which is Section 207. Under DC law, that takes us to the DC Arbitration Act, which is 164425.
So you can, as sort of your argument so far shows, every one of your arguments flows from the idea that we should look at this like an arbitration award. And I just want to know what you do with the language in the statute that says, for purposes of enforcement, treat it like a state court judgment.
Sure. So that language about treating an exit award like as if it were a judgment of one of the several states really just means that the court should not look back into the merits and the underlying proceedings there. So in Valores Mundiales, this court held that statement is really about preventing relitigation of issues that were already decided.
Well, that was the issue in that case, but nothing about the actual language of the statute is narrow in any way. It just tells us, treat it like a state court judgment. And so one thing that means is there's no basis to collaterally attack it. Another thing it means is, you know, if you have to go out and look for a time limit, why don't you look for something that relates to state court judgments, not arbitration awards? And why is that not, it's a pretty simple way of looking at the case. And why is that wrong?
So if you think of treat it like a state court judgment as meaning that in all respects and in all aspects of an enforcement action, you should treat it like a state court judgment, That actually creates a jurisdictional problem here because under 1605A6, you do not have, a court does not have jurisdiction to enforce a judgment related to an arbitral award. It only has jurisdiction over actions to confirm an arbitral award. And so basically this gets us to the same place that the Second Circuit was in Mobile Cerro Negro, where they were saying to give effect to that statement, I should understand it best as meaning we don't delve into the merits and therefore we're not doing kind of a long involved proceeding, but that doesn't displace any other types of procedural issues or considerations. So things like making sure that there's jurisdiction, making sure that you still have a plenary action, and in this matter, what the correct statute of limitations to borrow would be. And of course, Section 15101, which is what Titan and the district court have chosen, really doesn't fare any better under that language about treating it as if it were a judgment of one of the several states for a few different reasons. Number one, that is just a provision about judgments rendered within DC, so it doesn't apply to sister state provisions. And so it doesn't give effect to that part of the statutory language. The DC provision that is about sister state judgments is unworkable here, as is undisputed. And
why is it necessarily unworkable? If we say that it's not a DC court judgment, but we treat it as if it's a state court judgment or a foreign court judgment or some other sort of judgment, if you apply the DC statute, you look at where 12307, you look at where that judgment was rendered, and we know where it was rendered. It was rendered in Washington, D.C., so you can literally apply the act because we know from DC Code 12-307, what to do. We know where the decision was rendered, and it says the action can be brought unless the action would be barred there, and it's not barred there because we're back at the same place. It's the 12-year statute of limitations under 15101. So it seems like whichever way you go, you end up at the same place, 12 years.
I think there are a couple of differences there, Your Honor. So one is that a judgment was not rendered here. An arbitral award was rendered, and that is meaningfully different. So Titan in this action says that it's seeking entry of a judgment as it must. And again, if it were to characterize this any other way, it would have a jurisdictional problem. And then beyond that, the fact of an arbitration taking place in DC is not the equivalent of a state, a different forum rendering a judgment through its courts in the way under the DC code that you would then look back to the rendering forum state.
Well, what do we do with the language as Judge Garcia mentioned in the statute that says it's supposed to be treated as if the award were a final judgment of a court of jurisdiction of one of the several states? What work does that
So that's,
text do in your view?
in my view, what that text does is it prevents us from relitigating merits type issues or bringing the variety of challenges that you might bring in this type of proceeding in a different context. So both in the Valores Mundiales case and also in the legislative history of this provision itself, we see that this statement about treating an award as if it were a judgment of one of the several states essentially means that the district court is just precluded from inquiring into the merits of the underlying controversy. That's a very different task than what we're doing here in trying to figure out what the correct statute of limitations to borrow would be. So that statement does have effect. It does have meaning. It means there are various challenges to what happened during the arbitration proceedings that we could not bring at this stage, and that's correct. But it doesn't change the analysis that the court needs to do in terms of a statute of limitations to borrow. And so here, if we're looking for something that is really closely analogous, we could get either to the DC Arbitration Act or to the Federal Arbitration Act. Both of those get us to the same place because they both carry a 3-year statute of limitations. And the federal here is particularly closely analogous because, as the court recognized in its next era decision, Section 1650A is about enforcing, i.e. confirming ICSID awards, and Section 207, quote, likewise, is about doing the same under the New York Convention. So we have
Congress said Federal Arbitration Act shall not apply, full stop. So that seems a pretty direct. We don't often get them that direct.
So a couple of things about that. So first, we're not talking about applying. We're only talking about borrowing. And Justice Scalia in his agency holdings concurrence really made clear that there's a meaningful difference there. So if we were talking
Wasn't a
about
concurrence, but I've got a statute that says it doesn't apply. And what you want to say is that in fact provides the governing statute of limitations.
right. So if we were, there's no question here about whether that statute
Can you borrow
applies.
something without saying that we are applying that statute? We are applying that statute of limitations?
Yes, Your Honor, I think you can. You can borrow a statute of limitations and there's,
What do you do after you borrow it? You apply it.
after you borrow it, you analyze the claim under that statute of limitations.
And I do that by applying that statute of limitations. I just don't mentally know how I don't do that. And it just seems quite odd that Congress would say FAA off limits here and then expect us to use that statute of limitations. It seems kind of, and we'll go, well, we're just borrowing it. We're not really using it or applying it. Of course we are.
Well, Congress didn't say FAA off limits here. Congress made a specific statement about the FAA not applying. We again have legislative history about that exact statement, which says that the scope of that statement was really about the grounds for vacatur in Chapter 1 of the FAA. It explicitly links that statement to those grounds for vacatur. That's in the joint
Is there
appendix.
something ambiguous about the text that has me looking at legislative history?
I think the text is not ambiguous. I think there is a distinction between borrow and apply, textually speaking. If we're then getting into the kind of the next level question of, well, what does it really mean to borrow? What does it really mean to apply?
If I borrow, a lawnmower from my neighbor and just let it sit in my garage, that's fine. But if I use it, I have to then use it. That's the whole point of borrowing it, is so that you then use it. And I don't know how using it isn't applying that statute of limitations.
Right. I would think of it as you borrow the lawnmower from your neighbor and then you use it on your grass.
Right,
And
so
that's
I'm going to use the statute of limitations.
but you're not applying it
I
necessarily.
don't know what you mean by applying. It's not a Federal Arbitration Act case, but you are applying it. You're saying that's what governs here. That's what you want us to say. You want us to say that statute of limitations will be applied in every case under 1650A. And it will govern and it will control. I don't know what it means to sort of wink and go, we just borrowed it.
Sure. Even putting that aside, if we were to assume that there is not a distinction between the terms here, there's also the point that at that time that the statement was written, all we had was Chapter 1 of the FAA. So the only thing Congress could have
And I
been.
think that's, no, I don't think that's true. I don't think it's the only thing could have meant, because Congress came along later, right? And added more things to the FAA, but did not at the same time amend that provision.
That's correct, Your Honor.
So we can't sort of go, so they only meant it to apply. It's sort of this time limited thing that only applies to the old FAA and not the new FAA. I mean, we assume from congressional inaction a choice, don't we?
That's right. And in some sense, this point ends up being academic because this is only the question of whether you can actually get to a federal statute or not. And here, even if you look past that, the fundamental point that should drive the entire analysis here is the fact that we have to find something analogous, whether we're on the federal side or the state side.
Mm-hmm.
And on the state side, the most closely analogous provision, again, gets us to a 3-year statute of limitations.
Well, so because you're talking about 1644-25.
Yes.
So do you have any case where someone has borrowed a non-statute of limitations in this context? The problem is the DC code provision you want to use does not have a statute of limitations. So it seems very strange to say that the most analogous statute of limitations is a general catch-all that applies to, I don't know, is it a dozen or so different subject matter areas, 99% of which have nothing to do with this area.
Right. But
I've just never seen someone, every time we borrow a statute of limitations, we're going to another statute of limitations provision. But that your argument is go to this provision that has no statute of limitations and then borrow what it presumably is subject to.
Right. So this is not a matter of going straight to a catch-all. We're not saying the catch-all itself is the thing that is most closely analogous. We're saying 164425 is the thing that's closely analogous, and the statute of
We're supposed to
limitations.
borrow most analogous, the most analogous enforcement provision.
Right.
And the whole point of it, why are we borrowing it? Because we need a statute of limitations. That's the only reason we're borrowing anything, right?
That's
We
right.
need a statute of limitations. Are you aware of any case in any context where it doesn't have to be under 1650A,
Sure.
where a court said we need to borrow a state statute of limitations, and so we're going to invoke this provision that contains no statute of limitations, and then chase down what we think the statute of limitations under state law should be for that action?
Your Honor, I believe the Crocker case, which has been cited in the briefing in this action, did exactly this and ended up borrowing this exact catch-all statute of limitations. I can confirm that point, but I believe that does happen. And it makes sense because we have other case law showing that under DC 164425, the 3-year catch-all statute of limitations does govern that the actions brought under there. So the In Re Consul Rail case, for example, is one where that provision and action brought under 164425 was governed by that same 3-year statute of limitations. So I take the point that the 3-year statute of limitations is not in 164425 itself, but the two operate together in a way that the court would not be prevented from referring to 164425 as the most analogous provision and taking the statute of limitations accordingly.
No questions? No questions? Okay.
Okay, thank you.
Thank you. We'll give you some time on rebuttal.
Good morning, Your Honors, and may it please the court. Matthew McGill of King and Spalding for Titan Consortium. The judgment of the district court should be affirmed. At two levels, the text of Section 1650A defeats Argentina's argument here. First, Section 1650A directs courts to give ICSID awards full faith and credit as if they were state court judgments. That full faith and credit language is critical because it means a federal court must treat an ICSID award as a state court or a DC court would treat one of its own judgments. That points directly to DC Code Section 15-101 and its 12-year period for enforcement of DC judgments. Second, there is the Federal Arbitration Act shall not apply. And even if you took Argentina's view of what that means and doesn't mean, it does mean for sure that the Federal Arbitration Act's grounds for vacatur are unavailable in ICSID cases. It also is a very clear textual signal that Congress did not think that ICSID actions were in any way analogous to FAA actions. And the New York Convention confirmation proceedings are not analogous for the same reason. They allow litigation of FAA-type defenses that the ICSID Convention expressly forbids. Stepping back, approaching this as a question of statutory construction, asking, what did Congress intend by its silence? Congress could not possibly have intended in 1966 to borrow a statute of limitations that had not yet been drafted pertaining to a treaty to which the United States had not yet acceded. It's also utterly implausible to think that Congress intended by its silence to borrow any aspect of the one part of the United States Code that Congress said shall not apply. The court should be especially skeptical of inferring from Congress's silence an intent to borrow a statute of limitations that is so short as to regularly collide with ICSID's own appellate process. And finally, this 3-year statute of limitations would risk putting the United States in violation of its own treaty obligations under Article 54 to enforce an ICSID award as if it were a final judgment, because no state in the union or territory has a statute of limitations or a period for judgment enforcement as short as the 3-year period that Argentina is urging here. So for all of those reasons, we think that you should just follow the North Star methodology. Start with the strong presumption that we look to state law. Here, there is the ICSID statute and the ICSID convention itself points directly to state law. The Argentina discusses or raises concerns about the uniformity problems that would arise if we applied state law statutes of limitations, but that is baked into the ICSID convention itself. Article 54 at the United States' urging includes a sentence that says, if you have a federal constitution, you may treat the ICSID awards as if they were a final judgment of a constituent state. So it's baked into the ICSID convention itself that there would be some variation of within federal systems like our own. So there's no uniformity problem other than the ones that 200 and so nations agreed to, and that the United States agreed to when it signed the ICSID convention. And of course, that Congress must have intended when it used the same full faith and credit language that it is, that had a very well established meaning by that time in 1966, because the statute has been unchanged since 1790, and it has always required federal courts to look to state standards to determine the enforceability of judgments. So there's no uniformity problem that the Congress that should be.
If the district has consistently been treated as a state for this purpose.
Yes, I mean the Full Faith and Credit Act requires it. Absolutely, there's no question about that.
Sorry, why is ICSID structured this way as compared to the New York Convention? Do you know?
Because ICSID has its own appellate process. And this was, I mean, the New York Convention was covers a much broader range of arbitral awards. The New York Convention covers any commercial international arbitration award. The ICSID system is limited to investor state arbitrations, investor one side, state on another. We had practically 200 nations agreed on the framework here, where the awards are binding when they're issued. They have their own appellate process, and there is no litigation allowed outside of that appellate process, as this court recognized in the Valores-Mundial decision. When an ICSID award is brought to is brought to court for enforcement, the only question is whether ICSID itself would view the award as valid. That is the test, and that tells you just how unanalogous an FAA proceeding or a New York Convention proceeding is. And if you've been involved, as I have, in litigation of a New York Convention proceeding, there's a lot of defenses that are raised. Article 5 of the New York Convention has practically all of the same defenses that the FAA does. Incapacity, not valid under the law to which the parties have subjected it. No proper notice, due process concerns, beyond the scope of the arbitration, not in accordance with the procedure agreed to, violates public policy. None of this is allowed, none in an ICSID case. So the idea that the same statute of limitations would apply because one is analogous to the other is just flatly contradicted by the nature of those two litigations. So if we're borrowing a statute of limitations here, we should, as the text here clearly commands, treat it as a state court judgment. And that points directly again to section 15101. That is the most analogous state law, and I would submit the most analogous period for any statute that possibly, statute of limitations that possibly could be borrowed.
Can I just ask you about, so there was no stay during the annulment proceeding, is that right?
I'm not aware of there being a stay, Your Honor.
Okay, because the record says that there was a provisional stay and
Yeah, so the way it works in ICSID proceedings is when a party applies for annulment, it's automatically stayed by rule. The award is automatically stayed by rule while the annulment committee is constituted. And then the applicant for the stay can apply for a further stay from the annulment committee. And I'm not aware that such a stay was granted here.
Argentina would be the one to apply.
Argentina would have been the one to have applied, and it would have sought a stay of enforcement from the annulment committee. And of course, were there a stay, that would have raised tolling defenses of the type. And I would say, another issue here would be, well, what is the award, right? Is it the award that is that first emerges? Or is it the award that comes after annulment that adds on and tacks on the annulment costs? That would raise a different set of issues. But here I would say,
Well, do we need to know which it is? I mean, if we
No.
measure it from the annulment proceeding, end of the annulment proceeding, I think you're still within 3 years then.
that would be true, but I
So
would.
if that's the relevant award, then both sides win.
Except that it definitely should not be a 3-year statute of limitations.
But it
for all.
won't matter to you in this case.
It would not.
Right.
It would not.
So how do we, I had thought the language was focused more on, it sounded like the initial.
Well, I
But
think that
there's no case law in this country on when you measure the time from?
I'm not aware of any.
Since it's very strange to be doing a statute of limitations case without knowing.
Well, so
when it ran.
the point, here is the problem I see, Judge Millett.
Mhm.
The section 1650A says you treat the award, which would be both the first and the second award, but the award as a judgment entitled to full faith and credit. So most judgment enforcement statutes run from the date in which a judgment is entitled to full faith and credit. So
Is that I assume that's pre-appeal?
you mean pre-annulment or?
So well, we're talking about this.
Regular court?
State court judgments, right?
Whenever it would be entitled to, whenever that state would accord a judgment, full faith and credit. If a state did not accord a judgment, full faith and credit until after appeal, I'm not aware of any state that does that, but if that were the case, then that would be the rule. And there are some states that have res judicata rules that do depend on appellate review. So, but I think that this case could be and should be resolved on the basis that the district court decided it, and also on the basis that Judge Walden decided in the WeBuild case that section 15-101 is the most analogous statute here and is the appropriate one to borrow.
No, ICSID's been around a long time. And there's no decision anywhere in this country when the statute of limitations starts, whatever one you're borrowing starts to run.
Your Honor, I'm not aware of any decision in the world that has rejected an ICSID award on statute of limitations grounds. And I'm only aware of a statute of limitations being raised in the 3 instances that Argentina has raised it, which would be Blue Ridge, WeBuild, and this case. So it doesn't get litigated a lot, in part because ICSID itself includes no time limitation on the enforcement of its awards. And it says only that it must be accorded the same treatment as a judgment of a court of general jurisdiction in the contracting state. And we're the contracting state that applies these kind of time limitations to judgments of courts of general jurisdiction.
Questions? Great, thank you very much, Counsel. Okay, Ms. Ramamurthy, we will give you 2 minutes for rebuttal.
Thank you, Your Honor. So just to follow up on a few of the points we discussed on your question regarding a stay, if you look at the annulment decision JA 572, the procedural history makes no reference to a stay there. On the question of when the limitations period runs from, the Flatow case and the Apricard case, which we both cite in our opening brief, both say that the limitations period runs from the date the award is made or rendered. And then if we look at the ICSID Convention, Article 49.1, it specifies that that is the date that the certified copies were dispatched. So it is not correct to say that the limitations period doesn't begin to run until the annulment proceedings. It's the limitations period runs when the award itself is made or rendered. And
That is by the original ICSID panel or
By the original.
Not by the annulment.
correct, exactly, that's right. And where there are annulment.
But here the annulment proceedings added more money. Does that just sort of go back in time, or are there two judgments at issue here? Two annulment, not judgments, two, for purposes of our thinking of them as judgments, but two awards rendered.
I would not think of it as two awards rendered. So if you had a proceeding that was timely brought after an award was made or rendered, and then there were annulment proceedings that may or may not result in additional amounts, the district court at that point has the ability to decide what to do to manage the case there. So sometimes district courts grant stays in that context on the view that maybe.
I'm just asking, I've got an award from an ICSID panel, and I take it to court and say, please enforce this award. And then 2 years later, the annulment committee or whatever it's called, annulment panel says, not only are you right, you get that one, but you get another 3 million. Do I then take the decision of the annulment proceeding and go to district court and say, hey, guess what? Got another one, enforce this too for the $3 million?
No, you would not say got another one. That might be a basis to modify or change a judgment that was entered on the award, but it's not its own separate new award that deserves its own separate new judgment. It's just a basis to possibly modify what already exists in the proceeding. And that's why it makes sense that the limitations period is running from when the original award is actually entered. On the question about the catch-all statute of limitations, so it's the Crocker v. Piedmont case from the DC Circuit, 49 F.3D 736. And at 744, the court says that it's easy to disparage this limitations period as a mere catch-all, but since that provision does in fact embrace the claims that are at issue, and there it was personal injury claims, that it would be the most analogous that applies. And that makes sense also because when we're doing this analysis, you're trying to figure out what cause of action is the closest analog. And then the second question is, all right, what is the statute of limitations accordingly? So the fact of it being a catch-all shouldn't change that analysis. And ultimately, what this comes down to is really just about the nature of the action and finding something that is closely analogous. As we've said, confirmation of an award is the nature of the action here. And there's a real consequence to making sure that we think of the action as having that nature instead of having judgment enforcement. Because again, it would create a problem under the FSAA. You'd have an issue where you don't have jurisdiction under 1605A6, and that reading and that consequence would undercut what 1650A is trying to do overall.
Thank you very much, counsel.
Thank you.
Case is submitted.
Case number 24-1318. Beyond Nuclear Inc. and Sierra Club petitioners versus U.S. Nuclear Regulatory Commission in the United States of America. Ms. Curran for the petitioners, Mr. Averbach for the respondents, Mr. Runham for the Nuclear Energy Institute.
Good morning.
Morning.
My name is Diane Curran. I represent Beyond Nuclear and the Sierra Club. This National Environmental Policy Act case raises the purely legal issue of whether the NRC may, as a matter of law, refuse to evaluate two types of environmental impacts of reactor license renewal that it has conceded are reasonably foreseeable. First, the climate change effects on accident risk during the initial license renewal term, which would be between 40 and 60 years of operation, because the initial operating license term is 40 years. And then there's the second possible license renewal term that goes from 60 to 80 years. The climate change issue applies to both. The second issue is whether there are unique characteristics of aging reactor equipment that appear only in the second license renewal term that are different than everything else that's happened so far that ought to be considered in an EIS. I'd like to begin by explaining why this case is different from a recent Supreme Court case that is on everyone's mind, 7 counties. And there are 3 reasons. One is this case did not involve indirect downstream impacts that are under the control of a different agency. Everything here emanates from the operation of nuclear reactors that is within the complete control of the NRC. If the effects are indirect, it is because they're in the future. That's one understanding of indirect impacts. The minute the reactor starts operating in a license renewal term, of course, the risk starts, but the consequences of an accident would not happen necessarily until sometime in the future. The second aspect is this case involves a purely legal error. The only rationale the NRC gave for refusing to consider these impacts was if they were out of scope. Safety issues covered by the Atomic Energy Act. There is no exception in NEPA for a carve out for another statute's review. NEPA requires consideration of radiological impacts because they affect the human environment. So this is a purely legal error. And it's important to note that the NRC made that single defense in the license renewal GEIS in responding to comments, but completely dropped it in their brief, understanding we believe that this was legal error. Finally, 7 County is different in the sense that that case involved what the court called a comprehensive evaluation of the environmental impacts at issue there. In this case, we have none whatsoever, no analysis. And even if the NRC could point to, we have an Atomic Energy Act based analysis, it doesn't exist with respect to climate change.
So can I go back to the basic framing that you started with, which was these 2 things are environmental impacts.
Yes.
And I think the NRC would say that's not right. The environmental impact here is the harm that occurs if a severe accident were to come to pass. And aging and worsening, I think of it as storms from climate change, are 2 inputs into that risk. And when you look at the record, we actually studied that risk, the risk of severe accidents, quite extensively. Now, you might still have other arguments, but do you agree with that basic framing? These are inputs into a category of environmental impact. They're not impacts in their own right.
Judge Garcia, 2 things about that. One is that the NRC claims, of course, this is in the response to comments and in the brief. It's not in the environmental analysis that we were given to comment on in the draft. They say the severe accident analysis is conservative enough to embrace these issues. But with respect to climate change, in the brief, the NRC said, we don't understand climate change well enough to do it. So we ask ourselves, which is it? Did you do it or did you not? We do not believe they did anything. This is a post hoc rationalization for not looking. The agency put its head in the sand. We cannot see anywhere where this was analyzed. And with respect to the aging issues, what we have is a guidance document, no regulation, a guidance document that in the introduction says, this is voluntary, and we're looking to the licensees to resolve this issue. This is not, it's not NEPA compliance. If the agency is going to do that, they need to talk about it. What are the implications, the environmental implications of this decision-making process?
Can I just add one follow-up
Sure.
on the climate point? So I think what they say, it might be fair to characterize as them saying, we're not going to figure out how much worse this is going to get.
Mhm.
But what they do say is something like, we analyze this risk and what we have is a margin of error before we would call this category of impact significant of something like 100 times. And it's fast moving. It's difficult to study how much worse, the hurricanes are going to get over the next 40 years, but we're pretty darn sure it's not 100 times. And so this is their reliance on the margin.
Right.
So could you just specifically address that? Because if it were that there's 100 uncertain causes out there, but no one has given us a reason to think they're going to be significant in relation to the scale of this margin that we have, that does seem more reasonable. So I want to hear your answer to that.
Yes. Three things. First of all, the NRC's analysis of weather impacts so far throughout its history has been historical. The historical record, the NRC has never tried to, they use the word project, but they have never tried to anticipate how climate change might change these weather effects. It's an odd thing, but we're in the middle of one of these today, Hurricane Melissa. So they have never looked at that. And second, they have at page F12 of their GEIS, which is page JA 354. They say, we're going to make a plan. We're working on a draft plan, and we're going to look at these impacts for individual reactors, and we're going to look at mitigation measures. If that's what they're doing, then why aren't they doing it in a draft EIS? They're saying, we think there's something here that ought to be looked at. They're not saying they want to do it under NEPA. They're saying, we're going to do it outside over there at some time. We're not going to tell you when, and it's not going to have a bearing on our license issues. And then finally, NEPA requires, and this is held by this court in State of New York versus NRC, 681 F3D 471, that when the NRC does an environmental impact analysis of accident risk, it has to separate out probability from consequences. Those are both important issues with respect to these impacts, because, what we know about climate change is the likelihood of these events is going up. And we also know that the consequences of these events are going up. And the NRC uses a word they use the word additive, which is really another word for cumulative. Weather events add to the impact, the accident risks that we have. These factors need to be put in and demonstrated how they affect the probability and the consequences. To make a blanket statement, all this fits in our severe accident analysis, that's undermined by this plan that they supposedly have. And it's also undermined by their statement in their brief. We don't think these weather effects are easy enough to analyze that we could do it. So, we think that one of the purposes, and this is a holding of 7 County that we rely on, NEPA is a procedural statute. NEPA requires the NRC, if they're going to make a licensing decision that affects the human environment, put it in a draft EIS, what you think the effects are on the human environment, and give us the probability and give us the consequences. Give us your technical data, because we have members of the public, we have state and local governments, we have independent technical experts who want to review your work. and determine, do we think that you've done a good job? This is not reasoned decision-making. This case not just violates NEPA, but it violates the Administrative Procedure Act. The record does not
Brought that
conform
claim
with
here?
what?
Have you brought that claim here?
Yes.
So what I'm having difficulty with, and I guess this is following on Judge Garcia's initial question, is the relevant government action here, which NEPA is applying, is the licensing of a nuclear reactor to operate. And put aside that the generic EIS doesn't do that by itself, they still have to have a plant-specific one. Your argument isn't that the license causes environmental harm. Your argument isn't that operation of the nuclear plant itself is causing these harms. Your argument is if there's a nuclear plant operating and if a very big storm comes, then there's a risk that there'll be an accident and a risk that that accident won't be contained by the existing safety mechanisms already built into that plant. And so then there's a risk that there'll be environmental harm from that accident. Am I understanding your argument right?
Yes, there was just one thing that you said that I wasn't certain about. It all stems from the operation of the reactor. If the reactor isn't operating, you don't get the environmental effects.
But the action here, I mean, the New York case you referenced involved direct consequence of operation, a for certain one, right? How are we going to deal with, I think, was it spent nuclear rods, right? If this thing's
Yes.
operating, we're creating waste, and we got to do something with that waste. 100%. That's just part of the process. It's not just operating, but cleaning up after yourself, right? That's not what you have here. What you have is licensing, operation, and then operation itself doesn't create the risk. Then what you want to say, you have two things, aging equipment but put aging equipment aside for this question. So just climate change.
Okay.
Climate change creates a risk.
Can I just,
Climate change creates a risk
Go
that
ahead.
this operation will, if systems fail, result in environmental harm. So
Well-
it feels like this is an odd vehicle for this argument, as a NEPA argument.
we see this as climate change as a cumulative, or as the NRC would say, additive effect on accident risk. And, you have to back up for a minute and
An
see.
effect on accident risk.
Yes.
It increased the risk.
And there's no doubt
It
that
may-
accident risk is an environmental impact of a nuclear plant. That's well established. So the question is, what
No,
about,
it's a risk of an environmental impact. The mere
Yes.
fact of a risk is not itself an environmental impact. It's creates a risk of an environmental impact. That's why I say this is different than the New York case.
no, I would respectfully disagree, Judge Millett, because in that case, for
We got
instance,
climate change now,
one
as you
of-
just pointed out, and yet we haven't had any nuclear accidents.
one of the
Like-
risks, for example, was pool fires, spent fuel storage pools catching on fire.
Mm-hmm.
That's an environment, the risk was seen by this court as
Right,
an
but that's-
environmental impact.
You're going to have those pools there. Those pools themselves are dangerous.
Right.
And have, you have seepage risks and things like that. But here, your argument is that there's a risk that a storm will come.
Right.
They're not licensing the storms. There's a risk a storm will come, and then there's a risk that that storm will be of XY magnitude. And then there's a risk that if it's of XY magnitude, all of the existing safety protocols will not prevent harm that will then leak outside the operation of the nuclear plant itself and damage the environment. Am I understanding it right?
Yes, and I just want to explain that the NRC traditionally looks at this is called an external event. So when they do accident analyses, they look at internal events, which is what you're talking about, the piece of equipment breaks down. And then external events are weather,
And they
earthquake
looked at a
risk.
lot of, they did.
They look at a
weather.
lot of they look at weather, and they
look at
consider
storms.
that to be a relevant factor.
Okay.
And here, weather is now today understood to have different characteristics than it was understood when NRC first started looking at these things. It's still the
But
weather.
they looked at past weather events. Do you know what the
Right.
time range was for those past weather events?
The worst event in historical recorded history. That's what they look at. And then they assume that.
Sorry. Let me try the question again. Because my understanding is that the plants themselves are supposed to look at historical events, and they looked at historical weather events. What is the time range of that? If I submit a license or a renew license application today, what time period am I looking at for my relevant past weather events?
I believe it's the time period for which weather events have been recorded.
And so that's going to include up to about the time I file my
Right.
license.
But bear in mind,
Includes climate change.
okay, the way the NRC's regulations work, and this is 10 CFR 54.31B, I think. The applicant can apply for initial license renewal 20 years before coming to the end of a 40-year term. So that means they're predicting out 40 years. And New York versus NRC says they've got to look at that time period far out in the future. They can't just say, we're going to talk about what happened yesterday. They've got to predict. And for instance, when they go to the second license renewal term, they can make that application the day they start operating under the first license renewal term. So again, 40 years out, they're predicting what will happen to the very end of that license renewal term. This was the NRC's choice. They decided they're going to give these licensees a lot of time ahead of time to apply. But that puts a burden on the NRC of predicting, and it's not speculation. Or if they say, we don't know, then tell us on the environmental record so that the public and the state and local officials can see, wow, they don't know.
But you said they said we can't sort of predict beyond this.
They
So-
don't say anything like that in the EIS itself. They say nothing. The EIS itself just says, this is out of scope, case closed, go away. That's our problem with this. We never got to comment on anything. And there was never at any time in history a climate change rule under the Atomic Energy Act where the NRC said, here's how we're going to anticipate climate change and regulate it under the Atomic Energy Act. We didn't get that either.
But didn't they also say that climate effects are inherently localized? There'll be different climate effects.
Yes.
Okay, good. All right. So they didn't say nothing. They're doing a generic EIS here. They said these things are inherently localized.
Right.
So, and a generic EIS doesn't get you a license renewal. You still have to have a supplemental EIS at the individual plant, right?
But under the
Right?
license,
Is that-
no. Under the
They
license,
don't have to have a supplemental EIS at the individual
they
plant?
don't have to address everything that is, the purpose of the license renewal GEIS is to exempt the licensee and the NRC from having to address certain impacts in the individual cases.
No,
So
okay,
for
but-
instance,
So my comment's
Yeah.
correct. They still have to do a supplemental EIS. And
right,
if it turns out that there's, when you look at you told us NRC, we got to look at this as on a local, regional, let's just say plant specific basis. And it turns out this plant is sitting in what is now a common track for major category 4 or 5 hurricanes. Just to hypothesize that. Then why wouldn't that plant be under an obligation to address that? Because the generic judgment from the EIS would not govern its particular risks. It has, based on climate change, new and significant information that it has an obligation to address. And if it doesn't, then you could challenge that supplemental EIS, right?
A couple of things in response to that. First of all, the NRC does concede that climate change has site-specific effects, but the only way they look at that in the individual license renewal proceedings is the effect on local resources. They don't connect the dots between, like, the water levels going up in the lake, how's that going to affect my nuclear plant? They don't connect those dots. If a member of the public...
My point is not to bless or not agency decisions involving individual plants. The question is, you said they said nothing. They actually said this is local and regional. And if there's going to be these plant-specific processes before any license issues, I get they sort of get to check some boxes on the form already from the generic EIS, but that doesn't make them immune from an obligation to come forward with or a challenge based on new and significant information particularized to that plant. And so if they're not properly processing a particular plant's supplemental EIS and therefore its ultimate license decision, can't that be challenged there? Or are you saying, no, we can't challenge it there. We win here, or we'll never be allowed in the future to raise arguments about plant-specific climate change risks?
The problem with it is that when a member of the public gets to the individual license renewal proceeding, the first thing that happens is that we're told that this finding in the license renewal GEIS, this category 1 finding about the risks of an accident, is binding. And you will have to submit a waiver petition. So putting a huge burden on a member of the public, it's to do this. So it might be one thing if, for instance, the agency has to consider new and significant information, and you could come in with your hearing request and say, this is new and significant information, and you had to meet the ordinary standard for getting a hearing. But that's not the case. The NRC has insulated these findings from any kind of site-specific challenge by requiring waiver petitions, and none has been ever granted, although many have been attempted. It is a mechanism.
Can that decision be challenged?
Yes, and
Has it been challenged?
it has in different, there was NRDC versus NRC involving the Limerick plant.
Mhm.
But the point is that this creates a huge procedural barrier to the consideration of new and significant information that is not otherwise there. These category 1 findings have a purpose, and that is to expedite license renewal. It's not, they're saying, we're going to give you extra procedural hurdles to meet. And if the NRC thinks that this is appropriate with respect to accidents, they have not justified it on the record. There is no analysis on the record that would justify that category 1 finding. This is the place. These findings are applicable to, there's probably 30 applications that are either pending or coming down the road. This is the place where the NRC is making this crucial finding and hasn't put anything on the record. And then to say, we're going to kick this down the road to individual licensing proceedings where we're going to make the public comply with waiver requirements is, the utmost in arbitrary agency decision-making and not in compliance with NEPA. I know I am way past my time. I wanted to address the issue of vacator, but maybe I'm out of time.
I'll give you 2 sentences.
Okay. This case meets the Allied Signal Standard for vacator. There's nothing on the record. There's no harm to the utilities because the NRC is subject to the timely renewal doctrine, 10 CFR 2.109B, and they routinely grant exemptions if the licensees don't apply within their time frame. A recent case on that is San Luis Obispo Mothers for Peace versus NRC 100 F 4th 1039. That was the Ninth Circuit, 2024.
All right.
Thank
Thank you very
you.
much, counsel.
May it please the court, Andrew Averbach from the Nuclear Regulatory Commission on behalf of the federal respondents. I'd like to begin with two major principles. These points go to the context for petitioners' arguments and the standards of review that the court ought to apply in considering them. First, this case isn't about whether the NRC has ignored certain types of impacts because they're remote and speculative or present some kind of worst case scenario. It's about whether the agency has reasonably addressed one discrete issue in its generic environmental impact statement, specifically whether it has reasonably characterized the foreseeable impacts of the consequences of an accident in a nuclear power plant, and whether the 100-page analysis the agency has devoted to this issue is somehow incomplete or deficient because it concludes that the two sub-issues that petitioners have raised do not fundamentally alter the conclusion that the risk of a severe accident is small. Second, and relatedly, it's important to look at this case through the lens of seven-county infrastructure. In that case, it means that case means that the agency is entitled to deference, not only with respect to its technical determinations, but also with respect to the judgment calls that the agency makes in performing its environmental analysis, and in determining, as part of the exercise of that discretion, what types of information will meaningfully inform its decision-making process.
To get that deference, though, I don't think there's any dispute that you have to consider all relevant information.
Certainly, Your Honor, yes.
And when you're doing accident risk assessments, it has to be a reasonable accident risk assessment.
We agree.
How can an accident risk assessment be reasonable if it's not looking at the risk to come rather than the risk that was in the past?
That's a fair question, and I'll respond by saying that there is an extensive analysis of external events, the very types of events that are associated with climate. Certainly, and we take the information that has accumulated, and this was part of your question to counsel, up through today, or at least up to the date of the publication of the generic EIS, to determine what the potential risks are. And it is true.
The problem is that as was fairly pointed out, this is a really long-term license. So the license itself is 20 years out. And then depending on when they do it before they even need to get to that renewal line, and I get it's a long and complicated process, so they start early. But, it could be a 25, 30-year time period. Is it reasonable not to include, in addition to here's our thorough analysis of past weather events and their risk, our view of what the weather risk is for the time period of this license renewal, let's just say 30 years ahead?
Well, yes, I think it is reasonable. And let me provide.
It's reasonable to ignore the future.
I don't think it's quite right to say that we're ignoring the future, and let me explain why. First of all, there is margin built into the analysis, such that we're not just saying, oh, here's everything that's happened today. We don't have to go an iota further than what has happened up to today. Second of all, and this was the focus of a lot of the questions previously.
You said it was out of scope. Climate change is out of scope. So when you were doing your margin analysis, you weren't thinking about, sure, we've looked at past hurricanes or tornadoes, but you weren't thinking about the intensity and frequency and growing force of them going forward.
Well,
you said that's out of scope.
This was
clients. The commission said it was out of scope.
Let me be clear about this. And this too was remarked upon earlier. Climate change has begun. So in that sense, the up-to-date information that we're reviewing today or at the time of publication of the generic EIS includes trends that have accumulated up to the
Why
date.
you would say, so if this is, if this is how much increase in frequency there's been over the last 20 years and increase in severity over the last 20 years, then we project a similar or exponential. You guys are the experts in that. That's not the type of thing we would be
Right.
reviewing going forward. But instead you just said, we're stopping at the time of the license
We're
application.
stopping, but acknowledging that our regulatory regime provides for margin above and beyond that which has already happened. And then let me raise.
Where did the commission say that that margin in our judgment covers the risks of climate change on increasing severity and frequency of severe weather events where these nuclear plants are located?
At page JA 213, the commission references margin. Now, to be fair, it doesn't specifically say exactly what the court just suggested, which is this is the aspect of the margin that covers.
That was on the aging issue too.
You know what? You're right. That was 213 was aging. 222 is the page corresponding to climate change. But the agency has stated throughout.
Which language you're pointing me to? Where they say not that we got big margins, but these big margins we have made in our judgment. We have made a judgment are sufficient to protect against environmental risk from climate change.
There's no statement to that effect, Your Honor. But
So then that's my question. How can that be?
because
We began with, it wouldn't be reasonable not to look forward.
But because we know, 2 points I'd like to make. First, because we know that the environmental analysis has yielded a 12,000% decrease in the risk of accidents since these calculations were first performed in 1996. The agency was reasonably comfortable in concluding that its ongoing oversight of these plans, and that's an important issue I want to get to, is sufficient to conclude that the risk associated with even changing climate change will be
That's a sentence you
handled.
just told me doesn't exist.
I'm sorry?
You told me that they didn't make that judgment, that this margin, if they had said this margin, wow, that's a big margin. They definitely said that. But what they didn't say, and that is in our judgment, having looked at this weather trend, sufficient to protect against, to mean that our safety protections will apply, will reduce appropriately the risk from climate change accidents for the next 30 years.
Correct. But what the agency did say is that it has an ongoing regulatory process in place to ascertain the effects of climate change as they occur and to take appropriate action as part of its regulatory scheme to make sure that threats as they emerge are appropriately handled.
That's what's on 222.
Right, and-
If we learn new stuff.
And that's what I want to.
Information. Wait, so if I can just follow up on this. There's other parts, it's just curious. The NRC had that talked about, and I think it's one of the appendices, talked about how there are other government agencies can predict a track of climate change. There's information out there, which they did not factor into their margin analysis. So tell me two things. When they say on 222, if new information about changing environmental conditions becomes available, what new information beyond what expert government agencies already have gathered are they waiting for? And two, when they have that, what does it mean that they will change I don't understand how this language intersects with the generic EIS. So they will increase safety regulations. How will it be any process for the public and courts to review what they do? And if you could just, if they're going to adopt a regulation and that can be challenged, or I just don't understand how this paragraph here intersects with the generic EIS.
The court is correct that the generic and environmental impact statement alone is not the universe of environmental consideration. So to the extent that there's new information, new and significant information that emerges as part of the agency's ongoing oversight, and the agency certainly consults with its sister agencies who have even additional expertise beyond that of the NRC. To the extent that new and significant information emerges, then yes, that would be an appropriate candidate for consideration directly as new and significant information, or pursuant to the waiver process that counsel for petitioners has
Is it true
mentioned.
you guys have never allowed a waiver?
That's not correct. There have been waivers issues. I don't have them at my fingertips, but let me also point out that in New York, the NRC too, we had exactly the same arguments that were made. And this court specifically recognized that the waiver process was an appropriate means of seeking an escape hatch of some form from what counsel refers to as the forever binding nature of the category 1 determinations, or in a generic environmental impact statement. We are trying to.
Okay, sorry.
No.
Is there a waiver process that would now allow sort of reopening of the generic EIS, or is this waiver only going to apply? Because I thought it went with the new and significant information, which would only be plant specific.
The waiver process is a means of getting admitted to a licensing proceeding as part of the adjudication before the NRC. Typically, the NRC would say, you can't challenge a rule in an NRC adjudicatory proceeding. And petitioners would come in and say, well, in this case, there are special circumstances indicating that the rule shouldn't be applied. And one of the reasons they can say it is that, well, the purpose of the rule isn't applicable here because, as the court suggested, we have new information suggesting that category 5 hurricanes are likely to descend upon some particular area. And that would be fair game for such a challenge.
But what if the new and significant information, shows a risk? It's unlikely to be on one particular location. It could be an entire region, or it could be the, entire east coast of the United States, where there's multiple plants.
Well,
not all of which might have a license proceeding before the NRC at the relevant time.
True.
So if they need more sort of cross-cutting change, the risk is broader than a particular plant.
Well, 2 avenues, Your Honor. One is a petition for rulemaking. To ask the agency to redo its analysis in light of this information
For the generic EIS.
Yes.
Okay.
Or 2, the generic EIS itself specifically states that it is designed to be reevaluated at 10-year increments, so that we're not stuck in 2024 forever.
Well, you might not be, but you will have already issued an awful lot of licenses that are going to govern for the next 30 years. And let's say 5-7 years from now, oh my gosh, this risk is the storms are, I hope not, the storms are extraordinary. And a lot of these nuclear plants, surprise, surprise, are near water areas. And it's extraordinary. We've had a problem at one already with the terrible environmental impact. We've got to revisit this generic EIS. We've got to deal with this. We've got to change our regulations on safety. We've got to do a complete overall, kind of like your post-Fukushima one, only imagine it were here in the US. And then what happens to all those licenses you've already issued?
Well, that's an important point, and I want to make this clear. The dangers of a storm, of a hurricane, of a tornado, of an earthquake, those are things that the NRC monitors as part of its ongoing oversight of reactor operations, independent of the question of whether or not a license should be renewed. So let's just assume for a moment that the NRC issues a new license for a brand new nuclear plant tomorrow, and we don't then put aside our safety review of the plant or our ongoing oversight of the plant for 40 years. Rather, on a day-to-day basis, the NRC is monitoring events related to natural hazards. And you can certainly rest assured that were this hurricane to have descended upon the United States, there would be eyebrows raised about, well, what's going to happen now and to make sure that nothing happens as a consequence, and what steps need to be taken. And the court...
Do we have to wait till it hits the United States? I mean, this is not that far away.
I get that, and perhaps that wasn't the
Very
best
close.
explanation. Certainly, when a credible threat of something happening emerges, the NRC's antennae go up and make sure that all reasonable precautions are required of the licensee in order to maintain, or at least maintain adequate reasonable assurance of adequate protection. That's the NRC's mission. That's how the NRC in the main regulates nuclear power plants. It is true that this accident analysis is part of the analysis that it does in considering license renewal. But in the main, what the NRC does is to make sure on a day-to-day basis that these threats that might emerge are adequately identified, and that the licensees are required to take appropriate action as is necessary to maintain safety. That is ultimately the NRC's mission.
So there's, this is helpful, but I'm trying to understand again, there's been very, very serious hurricanes that have hit this country in recent years. And we now have had, at least a close brush with a Category 5, absolutely devastating, one very, very close to the United States. So when safety reviews are being done today on these license applications, is there an assurance that the existing safety regulations are strong enough to stand up to Category 4 or 5 hurricane? Eyebrow raising doesn't make me feel better.
Well, it's more than eyebrow raising. It's taking appropriate action
Right,
in
so
light of the hazards.
Has that already happened?
Well, let me point to the Fukushima example as an example of how the agency responds to threats. And granted, it was after the fact because the earthquake that precipitated it certainly had consequences in Japan. But the agency embarked upon a comprehensive program to improve its safety regime so as to not only take steps to, in that case, to take steps to make sure that licensees were taking precautions to prevent an accident and also to mitigate their consequences. And that's the agency's function. That's the agency's function on a day-to-day basis, irrespective of these snapshots it takes in connection with license renewal. And in the main, the agency accomplishes this through its ongoing safety oversight. It is true, Judge Garcia, as you suggested, that there is a comprehensive analysis of accident risk in the EIS itself, and that accident risk includes a lengthy chapter on external events. What we're talking about here are inputs to the analysis that the agency performed. And the question is of whether or not the agency should be entitled to deference in determining that these inputs didn't change the overall picture of the environment. Again, that's what NEPA is designed to have the agency capture. What is the overall picture of the environment that this particular action, the licensing, this particular agency action is going to have? And here the agency has...
Beyond the SAMA analysis done by the plant itself, when you're examining the risk of severe weather consequences?
Yes, Your Honor. There are all kinds of other inputs into
Weather inputs, risk of weather inputs.
Maybe I'm misunderstanding your question.
So the applicant prepares this, am I saying, I assume that's how you say the acronym?
SAMA, yeah.
SAMA. And that looks at how they're going to mitigate severe weather events based on entirely past events. I don't know how long in advance of the license that's prepared. I mean, it could be for the ones who did an original SAMA, that document could be 40 years old when they come to do their license
I
renewal.
don't think they're quite that old, but let's say 20.
Okay, 20 years old when they come in, 20 years old to predict out now for a 30 or 40 or 30-year window. If that's where you're getting sort of the analysis of how they're going to mitigate weather events, that seems grossly outdated. But you had said, no, we're looking up to date of at least license application. So that's where I'm trying to get the disconnect between their SAMA and then what are they providing you the information? Are you demanding it? Is there something that shows that the commission itself is going, thank you, that was very nice for 20 years ago. Where's your up to date analysis of how your plant is.
Well, that's predominantly accomplished through the day-to-day oversight of the plants themselves, the give and take between the licensee and the agency when storms emerge, present a threat. That's how the agency accomplishes safety. These SAMA analyses were originally designed to determine whether or not additional design alternatives or mitigation alternatives were appropriately implemented under NEPA. And they were a creature of NEPA itself. Now, in this court's decision in NRDC versus NRDC versus NRC, the court upheld the agency's determination that it didn't have to do more than one of these analyses. And so those analyses exist dating back largely from the time of first license renewal, so into the 2010s. But up-to-date information is provided to the agency, is gathered by the agency as part of its ongoing regulatory process. And that's how it determines in the main that it has reasonable assurance that plants should be able to continue to operate. And if the agency is concerned that some plant out there is not adequately prepared, it has tools in its regulatory portfolio to make licensees build a higher seawall, take action to mitigate the potential effects of flooding. And this is what I was trying to get to before. That's what happened post-Fukushima. The agency engaged in a comprehensive evaluation of the possible effects of a flooding or a sea level rise event that might affect plants. And as a consequence, all of the evaluations of flooding were redone. That's the kind of oversight that the NRC performs. That's the kind of oversight that the NRC will perform if confronted with new and significant information about changes to the environment, increased storms, increased winds, things of that nature that might be associated with climate change.
If 5 years from now, these petitioners say, look what's happened in the last 5 years with storm frequency and intensity and the damages it caused, and all those nice post-Fukushima seawalls, they're not going to be good enough when it happens. And they want to do this proactively, not reactively after an accident has happened. But look at these trends. Here's all these studies. This is going to get so much worse. What can they do? And the NRC hasn't done anything. What can they do? And this is not a plant-specific concern. Let's say it's the entire East Coast. What can be done to raise that before the agency?
Again, there are a couple of avenues. I mentioned the petition for rulemaking before. Certainly, they can come in and I don't know that NEPA is necessarily the best avenue to do this, but rather to ask the agency to look at its own safety regulations. And then on a plant-specific basis, licensee interveners can come in and file a so-called citizen petition.
Not
under
a specific concern, but yeah.
But there is a process under 10 CFR 2.206 to come in and specifically ask the agency to take action as against a particular license, to modify it, to suspend it, or even to revoke it because of an unresolved safety concern. That
But
process
if their concern is based on climate change, is the agency's answer going to be, that's already covered by our generic EIS, go away?
Absolutely not, Your Honor. And let me be clear about this.
That's what I think is
This generic and EIS has a role to play in the decision-making process for initial license issuance as well as each renewal. But in the main, it is a page-limited document designed to inform the public about risks and about impacts. But in the end, the agency's safety mission and the agency's safety review takes place outside of NEPA. And the 2206 process is outside of NEPA. It's not about amending the environmental impact statement because, again, we acknowledge this. As I said, on the hypothetical new reactor that might be licensed today, we don't wait until 40 years from now to issue a new environmental impact statement and address climate change that way. We address safety issues as they emerge. And our finding of reasonable assurance in connection with a grant is a dynamic one. So what might be reasonable assurance today isn't necessarily reasonable assurance tomorrow, again, irrespective of whether the license has been renewed or not. And the agency needs to maintain its vigilance, and it does maintain its vigilance. And I would point to the Fukushima example as the best example I have of that.
And have petitions for rulemaking regarding your Part 54, your safety regulations been filed on the basis of climate change risk yet?
Not to my knowledge, no.
Sorry.
I had a few questions. So on 267 of the JA, your brief references this statement that most of the external event risks, or at least it says winds, floods, and tornadoes, et cetera, are less significant than earthquakes and fires. Is that, and you cite that for the, I guess, the idea that climate change is going to make the wind stuff worse, not the earthquake stuff. Is that based on some, do you know, is there some other analysis of past weather events in the record that we could look at?
That is the extent of the analysis in here, but that's based on the NRC's experience in analyzing safety issues,
Okay.
and B, issuing new licenses, and also its experience with the modeling. And again, this is all part of a larger model that the agency prepared to determine.
Totally understand. Okay. And then on recent license renewals, at least I understand it's a long time between each plant coming and asking for renewal. But my understanding is over, say, it's an ongoing process. Sometime in the past 5 and 10 years, many plants have been getting these renewals. Is that correct?
Almost all the plants that were initially granted initial licenses throughout the 60s, 70s, 80s got an initial license renewal. Now we're in the phase, because time progresses, that some are now obtaining a subsequent second renewal. So the NRC has 90-ish license renewals accomplished. I don't know the exact number, but something in that nature.
And just as a general matter, when did those happen? In the past decade, the past 2 decades?
Past 15 or so years, I think is the.
And then there was a lot of, I just want to make sure I'm understanding. So you were discussing with Judge Millett, JA 221, or you could call it A 222. The very first paragraph says the NRC disagrees that we should consider climate change for postulated accidents. The last sentence is the large margin can account for a variety of uncertainties. It doesn't say exactly all the things we were hypothesizing, but isn't that linking the NRC linking the decision not to further study climate change caused risks to the existence of the safety margin?
I think that's
Or is that, am I reading it incorrectly?
No, that's a fair characterization. The margin is so enormous that the agency's understanding of where climate is not likely to cause any kind of significant change to its underlying conclusion that the risk, and this is the ultimate question in a NEPA case, that the risk of accidents is small.
So if we put aside, I understand your high level framing arguments, so don't just give me that answer to this question, but we've talked about climate change just on aging. Assume that, the commission largely proceeded as if we're going to deal with aging problems in our other programs, Part 54 and ongoing safety. Assume I think there needs to be something to point to in the record to support that being a reasonable assumption. So we're assuming our other programs will work. What would you point to in the record to say that's a reasonable assumption with respect to the risks from aging components?
The existence of the regulatory regime that the agency identified is proof positive that the impacts are likely to be small because the agency has confidence in its own aging management programs. I would further note, and this is what I said when I mentioned.
Yeah, well, let me tee up why the further thing is important is that the New York one basically says, you telling us you're on the job,
right,
we've got it, is not enough.
Right. Well, there's more to it than that. And let me provide a specific example. In New York one, we were largely talking about a circumstance where the agency hadn't performed an environmental impact statement at all, where there wasn't a 100-page analysis of potential accidents or of anything under review. And the court said, well, all I've got is this promise that you're on the case. I think that was the term the court used.
Yeah, and that's why I prefaced this with what I did. I just want to direct you to.
We have this regulatory regime in place. And an important fact here that in many ways, I think really addresses as a factual matter, the aging management issue is that the modeling that the agency performed included a so-called random failure rate of equipment that accounts for failures of equipment due to aging, or at least is a suitable proxy for that, such that the contentions that petitioners have raised largely go by the wayside and fall well within the margin we're talking about here, because we have, although we didn't need to do this because of the robustness of the regulatory regime, we still factored in, or we still factor into the analysis the potential for equipment failures, including equipment failures due to aging.
Thank you.
Thank you very much, Counsel.
Thank you, Your Honor.
Mr. Rund?
Good morning. May it please the court. It's Jonathan Rund for the interveners. Just want to start out by noting the 7-county decision makes clear that the scope and the depth of an EIS or matters that get substantial deference. Heard the petitioners try to say that it's really only about indirect impacts and cumulative impacts. And I think it's pretty clear if you look at Part 2A of the Supreme Court decision, it covers a lot more. I don't want to spend a lot of time on that. I think that's.
I think it just begs the question, though. I think you would not disagree that we can't defer to something that doesn't consider all relevant factors, issues in a reasoned way.
Precisely. And I think that 100.
That's really what this case was about. So.
Yeah. And if I could turn to that, I mean, the 100-page accident analysis, I think is well within the zone of reasonableness.
I did not read the opinion in 7-county to say count the pages if those pages aren't talking about the right issues.
Precisely. And the issues here.
Backward looking here and not projecting forward because that's out of scope. I just don't know what to do with that. That's out of scope. How can a license renewal for 25 or 30 years into the future say that what's going to happen to weather, and there's lots of reason to believe it's going to get worse, is out of scope?
I think it's best to read those out of scope comments, and then the comment response to that is essentially meaning the agency is exercising its judgment about really how much margin and what's built into the analysis. If you look at.
That's not what out of scope means. It's just not what it means, right? That's not. I just don't know how you can say that's what it means. What is out of scope? As it said there.
Yeah, if we look at JA 221, I mean, one of the sentences that talks about it being out of scope goes on to discuss the margin issue and what's been done on a site-specific basis for severe accidents. So if you look at what's actually in the analysis,
Garcia disagrees that the impacts of future climate change and mitigation should be considered for postulated accidents. The impacts of future changing phenomena on nuclear power plant hypothesized accidents are outside the scope of this GEIS and rulemaking.
I think what they're saying is two things. One thing, if you continue forward, that the NRC considered updated information about site-specific external events. If you turn to Appendix E.
Updated until it's passed. It's all updated as in like before the filing of this license application. Did you have any reason to think updated means a projection for the next 30 years?
Well, absolutely. So first of all, the plants are designed.
This decision doesn't say, when we said existing and updated information, we actually engaged in the very analysis of impacts of future climate change we just disavowed. What evidence is there that they looked forward into the period when the license renewal would be operating?
Well, I think it's important to have the context for how the NRC regulates these issues. The plants are designed, as the petitioner said, to look at information that's in the historical record. But the part that get left out is historical margin, the historical record accounting for unknowns, accounting for margin. So there's cushion that's built into how the plants are designed. And since the plants were originally designed.
Cushion begs the question of how much cushion and what informed the size of the cushion. And cushion was not considered with any analysis of future risk during the period of this license renewal, it doesn't do much good to say, if everything stays the same as it did for the last 40 years, we have so much cushion.
Nobody's assuming that things stay the same or static. The analysis that's in Appendix E is relying on the latest severe accident mitigation alternative analyses that have been done for license renewals up through the past couple of years.
What are they based on? What are they based on? Is it past weather events?
It's up to each licensee to go forward and present that information. They're basing it on their most sophisticated probabilistic analysis that they use for the
Based
plan.
on- What are the inputs? Is it past weather events up to the time of whatever reasonable time before I actually file it?
The latest information up until
What did you
the
say,
applications.
latest actual information of events that have occurred, or is it the latest information about prognosticated future climate change? Those are two different things. Which is it?
I don't think the record spells it out in that detail.
I think it's, there's plenty that says you look at the past trend, past trend of climate change. And that's what the companies are doing. And there's nothing other than this line about future climate change being out of scope that tells me that that the agency requires, maybe you can tell me a particular plant that has actually done this, but on the record, the requirements that are on the record now are not about prognosticating climate change risk for the next 30 years and its impact. And we are seeing storms that will exceed any margin.
I think it's important. Another thing to keep in mind is that the plants are updating to deal with climate change. We talk about, for example, in our brief, after the Fukushima accident, that the NRC requested information from licensees on updated flooding analysis to do that forward looking. We talk about one of those examples, the Turkey Point plant at page 30 to 31, footnote 67 and 34 of our plant, where the NRC, at the NRC direction, the licensee went ahead and did that projection looking at sea level rise up to 20 years. And as part of that, they looked out to 100 years, even though it's well beyond the license life. And the licensee was required to update their licensing basis and to make sure that they can account for that. And I think the fact that that is done.
One, Turkey Point, did the rules require after Fukushima?
Every licensee got
100-year forward projection on protection against hurricanes or the extraordinary amount of sort of even just water that is coming in.
Apologies for jumping in. I thought you were done. So every licensee got the requirement to look at what their unique hazards are. We have some plants that are on rivers, some that are on lakes, others that are on the coast, and every licensee was required to look at what was relevant to them. Some have more seismic risk, some have flooding, and the NRC provided extensive oversight of that, and they've since institutionalized that process. Yes.
It's just too vague for my question is, and this maybe there's a simple answer here, did NRC say that in deciding whether you are now safe against a Fukushima size tidal wave or that type of earthquake or similar hurricane force, storm rise, project forward 100 years, as Turkey Point, you tell me did?
I don't know that everybody was required to look at 100 years.
Did nothing require them to look forward? Did anything require them to look forward 50 years?
There was a requirement to look at what the relevant risk was for that plan. It obviously doesn't make sense to worry about sea level rise if you're on the Mississippi River.
That begs the question of what the relevant risk is. Did the relevant risk include forward-looking?
Yes.
Right. Fukushima's in the past. The next one's going to be worse. Did anyone? Okay. What in the regulation or what can you point me to that says they were required to look forward to increased risk beyond what we saw in Fukushima? Or was it just to protect against what happened in Fukushima?
No, the NRC went well beyond what was just fighting the last battle, essentially, and looked at what specific things would be relevant to different plants based on their unique environment. And I can't say that there's
On the coast.
what's that?
What do they require those that are on a coast to do?
The only one I'm familiar with, because we cited it in our brief, was the Turkey Point plan, and where they did do a full flooding reevaluation, and based on that analysis, which gets a lot of NRC oversight and review, they went ahead and looked at the sea level rise projections. NRC verified that modeling, does inspection. NRC has since realized that this is not going to be a one and done situation post Fukushima. They want to make sure that we are on top of these issues, we in the industry, on an ongoing basis, and they've since institutionalized an ongoing program to look at ongoing hazards. That's discussed. I think that's what's alluded to in terms of the general NRC oversight.
What is an ongoing? You just said ongoing hazards. What does it mean to say ongoing? Does that mean current level?
I may have misspoke. I meant it's an ongoing process to look at the latest hazards information. So if there's a new study that comes out from NOAA on hurricanes, NRC, through its interagency process, is plugged into that. They're plugged into the academic community to make sure that they're looking at it and they could figure out which plants are affected by those hazards and which aren't. Similarly with seismic type issues. So it's an ongoing process to make sure that we're not waiting until license rule to address those issues. I think that's.
NRC is so on top of this and is already doing this, making sure your plants are protected against forecasted harms, reasonably forecasted harms. Why was it so out of scope not to have it addressed in the generic EIS? They've got the capability. They're doing it. If it's part of the risk that they're enforcing, why is it not in the generic EIS?
Well, I'd submit that the NRC made the technical judgment that it is bounded. It looked at the increased risk.
Sorry, it is bounded? I don't know what that means.
So the context of which the severe, it's very technical 100-page analysis, but the NRC looked at the latest hazard information that's available based on license renewal applications that had site-specific risk from flooding and seismic issues, and basically determined, if you look in the JA 87 to 89 or the more detailed document at 256 to 257, it looked at the latest external events. External event is a technical term that covers a whole lot of things, including the types of risks we're talking about from climate risk. And the NRC actually said, you know what? Since we looked at this issue in detail in 1996, actually those risks could be higher. They can be 4 to 5 times higher. But the environmental risk isn't just the probability of an event happening, such as a flood. Environmental risk is what happens off site in terms of the impacts to the environment and the impacts to the public. And based on other new information, the NRC found there would be 120 times reduction in risk. And what the NRC, I think, is saying on page, I think it's fair reading of what they're saying in response to the climate change comments on page 221, is that when you have 120 time reduction in risk for things that have to do with source term, what material might get released to the environment, and you have a 4 to 5 times increase from the potential of external hazards, 120 is way swamps and cancels out any potential increase that you have from increased external hazards, including anything that might be related to climate change. And so when the NRC is saying the large margin can account for a variety of uncertainties, including imperfectly quantified factors in the risk analysis, and they're doing that in response to comments on the climate change issue, I think they're exercising the type of technical judgment and expert opinion.
It's out of scope, and so much of it seems to be backwards looking. But anyhow, I think we're over time here. Do you want to wrap up in one sentence?
Yes, just briefly. I think make the point that I think NRC has done a very comprehensive analysis, and they certainly responded to the issues and pointed back to the technical analysis that addressed the precise issues in terms of what external events are, and they've quantified those in a very sophisticated manner. I think that's precisely the type of technical judgment that the Supreme Court has said is entitled to this court's deference.
Thank you. Ms. Curran, we'll give you 3 minutes.
Thank you. I'd like to point the court's attention to Baltimore Gas and Electric versus, I guess, NRC. That's cited by everybody. In that case, and I think it's cited in 7 County, that involved a generic impact statement. And the Supreme Court said, NRC, you can do this, but you have to do it right. You have to comply with NEPA, because the point of a generic impact statement is down the road, this thing is going to be applied in individual licensing proceedings. Those findings are going to be binding, and it's going to be tough on the public to challenge that. So do it right now. Do it correctly now. And what we have here is an EIS that purports to deal with accident risk for the
me ask you
foreseeable
this.
future. Yes,
You commented on the draft EIS, right? Your client.
yes.
What, if any, comment that you made in that process was not responded to? Were there any comments that you made that that the agency failed to respond to?
No, it was the response that this is out of scope. That response is what we're here challenging. This is out of scope.
Didn't they explain further why it was out of scope?
Yeah, they
Just
said,
get to brass tacks.
yeah,
Not playing poker.
sure.
There's a rule of prejudicial error,
Yes,
and then there's language in 7 County about this is a procedural statute. It's not about outcomes. And if ultimately the agency might have used the words out of scope, but in doing so, and in explaining that, and in responding to your and other comments, they were making the point that they felt that other avenues, other safety regulations, other procedures, other things that were done were going to address this issue, then tell me how you're harmed.
because they didn't support what they said. They said, essentially, we did a safety analysis with these big margins, and that pretty much you could put the kitchen sink in there and it's not going to affect anything. And that to us was not NEPA compliance because they didn't support it. There is nothing in that EIS where they gave us, what's the data? What's the analysis to say this? There's nothing there. So a response to comments is, yeah, there's a response, but it's totally inadequate. And, we see in the NRC's brief, after they tell us we're the world's experts on accident risk, and then in their brief, they say, we don't know how to talk about climate change. We need to see that.
It's a NEPA violation for an agency to respond to something without adequate support.
Correct. And I just,
And your
go
best
ahead,
case for that is what?
is the Administrative Procedure Act, the NEPA requiring a rule of reason. A response to comment has to have.
I mean, what you're saying sounds to me like we're judging the substance of their response and whether their response was sound and adequately supported in an area of predictive and scientific judgment and all of those things where we're been told that deference is supposed to be at its height.
But if there's nothing there, if the NRC, it's clear that the NRC isn't looking at climate change. They don't have climate change regulations. They don't even have a climate change policy. They say who wrote the response to comments? This is a big margin of error and lots of things could fit in there. And we did comment, you're putting an awful lot of things because they said in the draft, we have a big margin of error. We said, you're trying to fit an awful lot of things in this margin of error. And there certainly is no indication that they explicitly looked at climate change. And that's a huge issue here. And it's going to reverberate, it's down decades from now in these individual cases where the failure to deal with this issue is going to bind in individual cases. And, it's one thing, we have to accept that a generic EIS, if they comply with NEPA, if the NRC makes supported, and I know there's discretion here, but there's got to be some findings and some data that a technical expert could evaluate and say, oh, they did look at climate change. They did look at these long-term aging effects. You can't find it, but down the road, we're going to be bound by this finding. You can't use the individual licensing proceedings to cure the defective license renewal GEIS. That is Baltimore Gas and Electric. And another thing that Mr. Averbach said, we have this separate Atomic Energy Act review, and then there's NEPA over here, which he referred to as a snapshot. If you go back to Calvert Cliffs, that's an old case, one of the first NEPA cases decided by this court. NEPA goes along with the Atomic Energy Act. It has to be included in the decision-making process. And what we see here is that the NRC really did treat it like a snapshot that you could rip up and, later on, too bad for the public when we come in individual cases and we're told we have an empty husk of a license renewal GEIS, but it binds you. We're looking for fundamental compliance with the the National Environmental Policy Act and the Administrative Procedure Act.
So I understand Baltimore Gas and Electric. You agreed that if there's new and significant information, there's the new and significant information exception, I guess, and the waiver process. So we would also, you don't disagree that those exist. You just think they're inadequate to allow.
We think that if the NRC did comply with NEPA in doing the generic EIS, these are reasonable procedures under NEPA and the APA. But the generic EIS has to comply with NEPA. You can't use the fact that we have procedures down the road to say, oh, well, try to get them to deal with this later on. We're here because the NRC decided to do a generic EIS. We didn't decide that. And we have the right to demand compliance with NEPA now.
I just have one last little factual question. Has anyone, NOAA studies this very closely. Has anyone anywhere put a number on how much worse climate change is likely to make storms?
I'm afraid I don't know that, Judge Garcia. I just know that what the accepted wisdom is, storms are going to get more frequent and more intense, and every time they look, it seems like it's going faster and more intensely than they thought last year.
Thank you very much.
Thank you.
All counsel, the case is submitted.
Stand. This court has come to the Monday, November 3rd at 1:30 a.m.